Hello, everybody. Just a couple of comments about a great question that we had from Rick. And Rick was focused on paragraph 48 of the complaint. And that's what's on our screen. And I guess I'll scroll up first to determine that it's count number 4. And it's in the negligence section. And if you read through it quickly, 43 mentions that the plaintiffs were invitees and business visitors. Invitees are people that you give permission to come in, as are business visitors. That's kind of the same thing. And the highest standard of care is required of a landowner who has business invitees. That is, if I invite you onto my property, I have a duty to take care of you. So one of the questions would be whether it would be foreseeable for a nightclub to have a problem with patrons becoming intoxicated and getting into fights. So that would be probably a jury question, and I'm inclined to think that most folks would think that nightclub would be aware of such a thing. So as I scroll back to paragraph 48, Rick had a couple of interesting observations that leads me to be able to discuss some things. First of all, there are really essentially two types of ways that a set of court rules can ask you to plead your case. One is fact pleading. In Pennsylvania, we are a fact pleading jurisdiction. And by fact pleading, that means that you are expected to plead every material fact to your cause of action so that there really shouldn't be any question whatsoever on the part of the person being sued about what it is they're being sued over. In the federal court system, they use the notice pleading system. And the notice pleading system is just a very general idea to the defendant of what they're being accused of. And the reason that the two differ is because both the Pennsylvania courts and the federal courts have a process known as discovery. And we'll spend plenty of time talking about discovery, but it's the part of a case where you exchange information about the case. And in the federal courts, they have very liberal discovery rules, so you can pretty much ask about almost anything. So the feeling in the federal courts was that if you were a defendant and you received a complaint and summons and it told you that you had done something, it was designed to put you on notice and that using discovery you could get more detail. In Pennsylvania, the thought was that requiring people to plead specific facts would get them to tell someone clearly and early about what the claim was all about. At one time, Pennsylvania was particularly stiff with respect to rigid rulings about having to make sure you've pled every fact. I think that has loosened up in recent years, but we are still a fact-pleading state. To give you an idea, if I were to have sent you an email today, in a fact-pleading state, it would state that I went to the Canvas learning management system, that I opened the email section of it, that I addressed emails to all of my students, that I hit the submit button and it was forwarded to your inbox within the Canvas learning management system. That would be telling you that I sent an email. In the federal system, which is just a notice system, it would say, I sent you an email today. That would be essentially the difference. That's the best I can do on short notice. So that would deal with two important aspects of pleadings, fact versus notice pleading. Rick had some interesting observations about, he was a little put off, and I understand it, over the fact that the plaintiffs allege negligence, gross negligence, carelessness, recklessness. And it's sort of like, well, isn't there one theory? Can't you be sort of clear about what you want? And why all these other competing theories? There's two things at play here. One would be the fear that let me first say, negligence is when you know something could result in an accident and you really try and be careful, but you just aren't quite careful enough. You knew what a standard of care might be, but you didn't quite meet it. It's a simple accident. We've all had them. You didn't mean to do it. You were trying to avoid it, and it happened. Recklessness is on the other end of the spectrum. With carelessness, I'm trying to avoid a problem. With recklessness, I don't care. I'm just going ahead and doing what I want. I'm not concerned with any standard of care. And I'm not concerned with it, whether anybody gets hurt or not. And that's generally where these cases usually fall, either in carelessness or recklessness. So you know, if you get convicted of careless driving, that's less serious than reckless. Reckless is a much higher penalty because you drove without any regard for the roadway or people. So that said, attorneys are generally afraid that if they don't plead all of them in this one piece of litigation, things won't be included that should have been included, and you might lose the case because you didn't have a recklessness claim, or you had recklessness but you didn't have carelessness. So they generally throw them in. In the court rules, it will say that even inconsistent theories of a case can be pled. You don't know when you put all these things on paper what the eventual decider of the case is going to actually believe. That decider of the case, we call that a fact finder. And that fact finder in a case could either be a judge or a jury. So you make all these contentions with the hope that one of them will be believed. And that's why, or that's the system that we have. There was an interesting observation, I thought, as well about, I mentioned that the bottles were supposedly $1,000 a piece. And it was thought, gee, why didn't you disclose that? I'm not sure that it's necessarily pertinent for these pleadings, but certainly in their testimony, I'm sure that would come out. The question I would have is, can you fight over a $1,000 bottle but not a $25 bottle? I don't know the answer to that question, but I think that probably, I'm not sure. I don't know how the $1,000 sounds. It would be up to a jury as to whether or not you think they'd be influenced by it. I kind of think, I don't know. I've never spent $1,000 for a bottle of champagne, and I kind of hope everybody listening to this hasn't either. So I don't know the reaction, but I think I sort of have a feeling, as Rick did, that it seems wasteful. It seems overdone. Another comment was with respect to drunkenness and whether that was really a factor in all this. The Dram Shop Act, which I mentioned is also included in this case, requires that the liquor license holder serves alcohol to a person that's visibly intoxicated. Then, once that happens, pretty much anything that happens within the establishment as a result of that person having had too much to drink is going to be the responsibility of the liquor license holder. So they'll probably be trying to focus on what they can show to show that any of the people that engaged in this melee were intoxicated. The reason, and I've been involved in a lot of cases where you were asserting people were intoxicated. I think the purpose is to suggest that people weren't using good judgment. So whenever there's a fight, people always would want to say the other person was drunk, and that's why they acted so crazily. There's a factor that I'm not sure, I don't recall, is in the pleadings, but well, there are actually two factors that I think are interesting, and see if you have any response to it. Everybody is African American. That's one factor in the case. Secondly, the two plaintiffs are Philadelphia police officers. So one of the concerns I had when I read the story was, what are police officers doing in a nightclub at 2:30 in the morning? I don't know the answer to that. They certainly have a perfect right to be there, and they certainly have a right to spend $1,000 on a bottle of champagne. It doesn't, to me, if I were on a jury, I think I'd be wondering, what are police officers doing in a place like that at 2:30 in the morning? In other classes, I've had a fellow that has a tremendous amount of civil trial experience talk to us about this case. And I don't want to disclose what he said just yet, but I'd be curious to know what your sense of it was. He had views of the case that were probably honed over about 30 years. Just be curious, I'd be curious, what's your evaluation of the case? Do you think that this case would be one that would result in a large verdict? I can tell you that both plaintiffs were seriously injured. I think broken noses, broken ribs, lacerations. I mean, they got beat up pretty good. This wasn't a one-punch thing. If you've seen some of the video, it's quite a melee, and people on the floor are being kicked by, looked like a few people. I couldn't tell exactly who, but they were all being kicked by obviously some people in the group of defendants. Well, I just wanted to address that. I thought it was a terrific question, and I really wanted to give you my response to that. So thanks for listening.